Hey guys, Paul Rabelais here, estate planning attorney. Going to focus this video and one other on the two forms of Louisiana wills. There's only two forms of what Louisiana calls testaments. Some people call it last will and testament. Two types and two types only. This video is going to focus on part one, which is going to be the Olographic Testament. Part two, which you can watch in another video, will be about the notarial testament. That one's actually more common. Okay, so let's jump right in. This one's going to focus on what's called the Olographic Testament. Some people say it's a handwritten will. And the first thing that we're going to take a look at is, what does Louisiana law determine as the definition of an olographic will? And whenever we're defining terms, I got to pull out the law. And while I hate to read it on a video, every word is important. So let me just jump right in. So an olographic testament, testament means will, is one entirely written, dated, and signed in the handwriting of the testator. The testator is the person who's writing will. So if Fred Watson wants to write his will and he writes his will, Fred is the testator. Okay, so then it goes on to say, because now there's all what if, because the problem, they have to kind of define things because there's been so many court cases over the years where people tried to write their own wills, and different people did different things, and there's no standard. Everything gets interpreted different ways. So we go on to say, although the date may appear anywhere in the testament, the testator must sign the testament at the end of the testament. Sounds pretty clear. Must be signed at the end. However, over the years, court case, somebody, signed at the end, and then they wrote more stuff, and judges didn't know what to do, and legislatures didn't know what to do, so the statute goes on. If anything is written by the testator after his signature, the testament shall not be invalid, and such writing may be considered by the court in its discretion as part of the testament. Oh, brother, here we go. Somebody writes a will, they sign it at the end, then they write more stuff. Is it valid? It's not invalid, but court in its discretion may consider it. So that gives a lot of certainty there. Go on. The Olographic Testament is subject to no other requirement as to form. And here we go with some ambiguity about the date, because sometimes over the years people wrote the date, they wrote it out. They wrote numbers, they didn't put the year in, so here we go. The date is sufficiently indicated if the day, month, and year are reasonably ascertainable from information in the testament as clarified by extrinsic evidence if necessary. Oh boy, okay. So we started with it must be entirely written, dated, and signed in the handwriting of the testator, and the signature must be at the end, and then there's just some qualifying statements, and then there's one other sentence or paragraph. It says additions and deletions on the testament may be given effect only if made by the hand of the testator. Okay, so with all that being said, it's pretty easy to make a valid will. The problem that happens just about every single time is the words that are used in that valid will by a layperson often don't accomplish everything that person was hoping to accomplish. So let me give you an idea. Let me show you how easy it is to make a valid last will. And so let's say Fred Watson sat down, pulled out a piece of paper, said, you know what, I'm going to save a few dollars and I'm going to write my own will. And he pulls out a piece of paper, and I don't know if you can see this or read it, but you'll get the picture. Here's this piece of paper, and he writes the date at the top, December 7th, 2018. And then he goes on to say, I, Fred Watson, leave my estate to Mildred Watson. And then he signs at the end. So it's entirely dated, written, signed in his own handwriting. And really, I did this, and I'm not Fred Watson, so this is just an example. Problems could surface when Fred dies for a bunch of reasons. Let me just scratch the surface. So what if old Millie happens to die before Fred? Let's say that's his wife. Probably at least a 50% chance that she's going to die before him. So does it wind up going to her estate or her heirs? Answer to that is no in both things. So you got to cover certain contingencies that may occur from the time somebody writes the will until they pass away. Doesn't mention anything about an executor. Sometimes the court has to appoint an executor to handle and administer the estate while all this stuff is being, settled. And then not only does it not appoint an executor, if it did appoint an executor, it may not have appointed an independent executor. Less court supervision than when there's just an executor. So none of that's addressed. And then what if, Mildred is alive when Fred dies and she inherits everything and then she gets married again? And she winds up leaving everything, including what was Fred's, to Mildred's new husband. And maybe Fred had kids and his kids would be left out completely. And this handwritten will, it's gonna require that there be a court supervised probate proceeding. So Mildred, if Mildred's alive when Fred dies, is gonna have to hire a lawyer like myself, and we'll have to get other parties involved to go through the court proceeding, getting a judge to confirm that the will is valid, all the inventories of assets, and ultimately court orders ordering that Fred's assets be transferred over to Mildred. Some people think that having a will means that the probate proceeding is unnecessary. Really nothing further from the truth. Having assets in your name requires the probate or succession proceeding when you die, regardless of whether you have a will or not. And then some people think getting their legal affairs in order is writing a will, but there's so much more to it than that. Again, just scratching the surface. None of the who can handle my stuff if I become incapacitated, who can talk to my doctors, access my medical records, sell my vehicle if necessary, and none of this addresses that. There'll be more court proceedings should Fred become incapacitated and his signature or other decisions are required of him, but he's not able to do it. In addition, the old Fred will doesn't address ambiguities and errors, so this is an example where somebody wanted it to be really simple. Other people go to the other extreme. They handwrite things, but they make it really, really complicated, and circumstances change from the time they write the will till the time they pass away. So I was involved in one time where I was presented with the will after the woman passed away. She handwrote her own will. She had cancer. She didn't have much time to live. She didn't know any better. She had a home. But her mother lived with her husband lived with her, and her young adult daughter lived with her. So she put all these conditions in her handwritten will as to how that home was supposed to be handled and owned and who was supposed to be able to live there. And so it was a nightmare of a probate proceeding. A judge had no idea what to do with the title of that home after she passed away. So just her putting her thoughts on paper really messed things up, not doing it in the right legal form, using the right legal language. Sometimes handwritten wills don't address the entire estate. I've seen a lot of handwritten wills. I leave my house to so-and-so. I leave my bank accounts to so-and-so. I leave my vehicles to so-and-so. That was the only things on their mind. Later they pass away, they own other stuff. And so they didn't have this residuary clause, as us lawyers call it. And so they didn't cover everything. Sometimes people do their own handwritten stuff and they cause a real mess because they leave an outright inheritance to either a minor or an irresponsible person who's perhaps an adult, and then money gets squandered. It goes through the court system when it goes to a minor because minors can't inherit. So we have to have these other court proceedings called tutorships when you leave something to a minor. That all of that can be eliminated by doing it the right way. Bottom line on holographic wills is it's possible, if not easy, to create a valid will. However, that's the easy part. The challenge and getting it right is just not making it valid, but it's covering all the things that need to be covered, including reasonable contingencies, and just kind of know that the future costs of cleaning all that up will likely far outweigh any savings that you may have felt like you had recognized by doing it on your own. So that's the Olographic Testament part one. Next video is going to be part 2, which is going to be about the notarial testament, a more popular form of testament or will in Louisiana. So you're going to make sure you're going to want to watch that one. More validity requirements, but more often than not, it's done right and covers all the necessary aspects and contingencies that need to be covered. All right, hope that helps. That's part 1 of 2. That's the holographic will. Next, notarial. See you around.